Good morning, folks, and thank you for joining. We'll give it a second here for folks to join, and we appreciate you being here, patiently waiting for us to hit that start button. I am sharing my screen. I hope you all can see it. So welcome to our webinar. This is a second one on FAR parts. We did the FAR part previously, and now we're doing FAR part 19. Appreciate you guys joining, and as always, we appreciate PilieroMazza and Alba for being with us and giving us the real knowledge of what is going on with the FAR part changes. My name is Reena Bhatia. I'm the CEO of Proposal Helper and Bid Execs. And we hold these webinars on different topics, talk about different things going on in the industry. So I appreciate you all being here. Quick housekeeping as I introduce myself and then hand it over to Sai to introduce PilieroMazza and his company and himself. If you have questions, please submit them in the Q&A channel. We are not watching the chat for questions. The chat function is for you all to network with each other. So feel free if you want to share your contact, network with each other, use the chat box for that. As far as questions for us, we will be monitoring the Q&A channel. So please post your questions there. And let me introduce myself again. As I mentioned, I'm Reena, CEO of Bid Execs and Proposal Helper. I've been in the industry for about 30 years, a little over now, and look forward to supporting you all. We started Proposal Helper 15 years ago, going strong so far, and thankfully, through all these changes, and Sai and I were talking in the background here before we started about what to expect with the shutdown, when will it open, and I know the industry is just as eager, but that's not the topic of our discussion today. I'll just quickly say, if you guys need business development, capture strategy support, proposal support, we are here to help you. Please reach out to us. With that, I'm going to hand it over, Sai, to you if you want to switch and or introduce yourself and then switch screens. And please go ahead.
Yeah, here, I'll go back ahead now. There we go. Hey, everybody. Yeah, my name is Alba, partner with PilieroMazza, do a lot of work with federal contractors and certain commercial entities in various areas. I do a lot of corporate M&A work these days as well, dealing with the federal procurement space, protest claims, you name it. PilieroMazza, we've been around for a long time. I think the initial iteration of the firm was in the late 70s. And so I've been with the firm for about 19 years, or exactly 19 years. I just had my 19th anniversary. And so we kind of help commercial and federal government contractors with all these items here, all manner of things. So obviously happy to help. And one of the big things we deal with are a lot of the government contracting, small business issues. Been doing that for many, many years now. And that kind of ticks off our main topic here. And before we get started to the point about the shutdown stuff, one thing I just want to note is that these FAR changes are sort of a moving target, right? They are looking for input from folks, and there's going to be probably additional changes. There's implications between SBA rules and the FAR rules that we're going to get into, and everybody needs to be prepared as things turn back on. There's been some rumors that maybe it'll last another couple weeks, maybe it'll be before Thanksgiving. Maybe they'll do a short-term thing and then shut down again in January. And if something like that were to occur, everyone needs to be prepared, I think, to move rather quickly because there are still goals, they are still pushing small business issues, and if proposals are due, there might be very short turnaround times towards the end of the year. So just be prepared for that and be prepared to move rather quickly. Or if you've got outstanding issues with government folks that once they come back online, they're going to have a big line, I think, of people trying to talk to them. So just be prepared. When we're getting into the topic at hand, though, and the FAR overhaul here, FAR Part 19, I think, was one of the big issues that everyone was waiting for. Our last little chat was on FAR Part 6. And not to like pat myself on the back, but kind of. I told everyone that maybe we should calm down a little bit on some of the changes in FAR Part 6, that people were analyzing them and looking a little too closely, I think, and thinking that maybe there would be bigger changes, that the rule of two would be scrapped and things of that nature. And I said in that prior presentation that we should probably calm down a little bit. And I've heard from various folks on the Hill and other places that that likely wouldn't happen. And apparently, from my further discussions with folks on the FAR Part 19 rewrites and some of the FAR overhaul committees, it was never going to happen. They had never put the elimination of the rule of two on the reader board. Not sure I completely believe that it was never on there, but because of the congressional push, it never really occurred. So that's good news, and we'll certainly go through with a lot of that. Even though it's not statutory, the rule of two is not statutory. It didn't get taken away. Some of the basic issues, you'll notice that instead of small business programs, it's just called small businesses. Again, I think they're just literally trying to remove words to make it shorter, which is somewhat interesting. Most of the content remains intact, and things that were removed or taken away, there's still 13 CFR, which is not part of the FAR, but it's SBA's regulations. And those regulations still govern. So you have to pay attention to both FAR Part 19 and 13 CFR, and I'll talk about some of that. Really, like I said, they cut out a bunch of words, and that's fine, I guess. Some of it, though, was probably decent context. But the rule of two has been retained, and again, the whole point of this allegedly is to try to make things a little more clear, and we'll see if they've actually done that. As with every other section, they've reorganized FAR Part 19 and restructured it so that instead of the way it was set up, every FAR part now is set up in this same general way where there's pre-solicitation, evaluation and award, and then post-award. So it's set up in a temporal manner as opposed to how things were set up previously. And that's not the worst thing in the world. So just be aware of that. That's how things are now structured. And you'll also see that some of the definitions, instead of having different definitions in different places, if you're looking for the specific definitions under FAR Part 19, they're all going to be in 19001. Now, the different definitions or the more general definitions that apply to the FAR overall are still going to be in FAR Part 2. So just be aware of that as well. If there's a term that is not defined and it's not in 19001, you should look at FAR Part 2 to be sure, because those definitions are critical to fully understanding like what everything means in the new changes. Another thing I think just to note is also that these changes are still subject to further change and comment. So, to the extent that there's commentary or if folks want to submit their thoughts on the various changes, they are looking for that. And these are not final rules as of yet. They are proposed rules until everything gets completed and they actually push these through as final. And I think another piece of this, and this might seem like fluff, but I think it's still instructive, that if you look at the general policy here under FAR Part 19, it's really remained unchanged. So they're still looking at it from the perspective that, look, it's the federal government's policy to provide maximum practical opportunities in its acquisitions for small businesses and other small business socioeconomic categories. So they're still acknowledging the fact that the government is looking to do business with small businesses and that small businesses are still a cornerstone of the economy and the industrial base. And specifically, you'll notice that this is also mirrored in the Small Business Act, which is probably why some of these things haven't changed. And I know there's been a lot of discussion out there about, well, are they going to eliminate this? Are they going to eliminate that? Are, are serviceable vet things going to be the favored child, or is woman owned going away? Is 8A going away? The reality is that those would really take acts of Congress. And I think I might have mentioned that before, but the Small Business Act is a law, and law trumps regulation when it comes to interpretation and applicability. So, unless the government were to change, meaning Congress passing a law signed by the president, were to eliminate or amend the Small Business Act, that law would still trump any sort of changes that would have occurred via regulation. And then in addition to that, and this is something I'll touch on a number of times throughout this discussion, FAR Part 13, which is SBA's regulations, actually trumps FAR Part 19. I'm sorry, not FAR Part 13, 13 CFR trumps FAR Part 19 because Congress, who has ultimate authority to draft legislation, pass laws, that Congress delegated its authority as to matters of size or status in federal procurements, among other things, to the Small Business Administration, not to the FAR Council. So when you're looking at some of these changes that we're going to go through, you also need to pay attention to ways in which the new FAR Part 19 might clash with 13 CFR. And in those cases, the courts and GAO have deferred to SBA and 13 CFR because that's just the way our system works, that Congress delegates its authority to whomever it delegates it to, and that authority is what governs. And so the Small Business Act told the administrator of SBA to take certain actions. The administrator of SBA took those actions vis-a-vis 13 CFR, and those actions should govern even if there's a difference in FAR Part 19. Now, going to like the big like sort of headline or the big worry that everyone had, this idea that the rule of two was going away, right? Well, the rule of two, as it historically existed, is sort of the main underpinning of small business set-asides. The meat or the real impetus for small business set-asides was this rule. And so it used to say if there's a reasonable expectation that the contracting officer will obtain offers from at least two small businesses and it can be awarded as a fair and reasonable price, then it should be set aside for small business participation. Later, it was changed, and these are older changes, to make sure that there was parity between all the programs because there was a drafting error years ago that actually put HubZone first in the whole hierarchy of things. And that was then changed and amended so that there was parity amongst all the programs and that contracting officers had the discretion to determine which type of set aside they wanted to have. So, did they want it to be 8A or woman owned or HubZone or serviceable vet or whatever it was? Now, one note I think here too is that even under these new rules and under the old rules, the VA has a law that governs specifically how the VA is supposed to operate. And so that is one of the only agencies, or maybe the only agency I can think of, that has a specific law that governs its set aside authority and the hierarchy. So for VA procurements, and that's anything let by the VA, which would include, as far as the courts have interpreted it, task orders under GSA schedules or task orders under GWACs and things of that nature, that anything let by the VA has to go serviceable vet first. They have to look at whether or not there are two or more serviceable vet firms. If not, they then go veteran owned firms. And if not there, then they can go to small business. And then the new rule of two would apply. So just be aware of that the VA is a little bit different. But under the old rule, again, and this was one of the things people I think were worried about, it was under the old FAR 19502-2B. And that said that any acquisition shall be set aside if it's over the simplified acquisition threshold. So that's key, over the simplified acquisition threshold. So that would literally be everything. If you can obtain offers from at least two responsible small businesses and it can be awarded at a fair and reasonable price. So that old rule basically said that this rule of two and the requirement, the mandatory nature of small business set asides occurred both under the simplified acquisition threshold until you get to the micro purchase and above the simplified acquisition threshold, so long as your market research made these two determinations of two or more small businesses at a reasonable price. That is the main thing that people, I think, were worried about going away, or what was going to happen. How was it going to be treated? Under the new rule, and it's been moved so that it's now 19104-1 because 19.1 is all the pre-solicitation stuff. So again, remember that. It now says that a set aside for small businesses is the limit of acquisition exclusively for participation by small business concerns. And then for contracts above the micro purchase threshold, the contracting officer must set the contract aside for small businesses if there is a reasonable expectation of obtaining offers from two or more responsible businesses and that there are competitive terms of fair market prices, quality, and delivery. So as you can see, the rule of two has been retained and arguably is in the same or extremely similar place as it was before. So even if you're in a situation where something is above the micro purchase threshold, which has also been proposed to increase, a lot of the different thresholds are now being proposed to be increased. And although they're not final yet, so they're not completely being used as of now, and are still subject to change. So just be aware of that too. If you've heard different numbers being thrown around, and as long as there's two or more responsible small businesses and it's a reasonable price with quality and delivery taken into account, which is a little bit of a nuance, then it's supposed to be set aside for small businesses. It doesn't expressly state that there's any sort of hierarchy or as discriminating against any sort of socioeconomic categories like woman-owned, service-able vet, hub zone, etc. The use of the term set aside for small businesses just again retains the contracting officer's discretion to make the determination as to what set aside type they want to use. So again, this hasn't really changed how this should be worked in practice. I guess we'll see the reality of the scenario. And I know there's been fewer 8A contracts let and things of that nature that I know a lot of people have been focused on. That's kind of a maybe a policy judgment, but as of the actual law, it hasn't really changed that much as far as how these things are supposed to be done. So again, it's preserving the real essence of the rule. It does, though, say, look, the contracting officers don't have to sit there and consider socioeconomic categories before just generic small business set asides. So that's a bit of a change, but to be honest, there really wasn't a good mechanism to challenge contracting officers on doing this. And really, in the past, they've looked at who is out there that can do this work the best way. Is there a particular contract? I mean, let's be honest, right? They looked at whether or not there was a particular contractor they liked working with. That person was a vanilla small business, or if they were no longer 8A, or they were no longer woman owned, or whatever, and they still wanted to get at that person, they could make certain determinations within their reasonable discretion as they're evaluating other set aside types to somewhat steer. I know that sounds bad, but to position the contract in a way that that their preferred contractors or group of contractors would be able to bid on things. So I don't know if this is a practical change as so much as a change in the nomenclature being used, because it's still in reality the contracting officers had a lot of discretion in how to do these things. But that being said, the now official policy is to move away from the prioritization of socioeconomic categories and to allow the use of vanilla small businesses in a broader context instead of having to even sort of think about other ways to procure things. In addition, the new FAR 19111-2 explicitly states that contracting officers have discretion to set aside all orders under any multiple award contracts and that it's not subject to protest. Now, that being said, this too isn't really a major change because under like years ago in 2008, I won a case of the GAO called the Delex case. And in that particular case, the GAO found that the rule of two applied at the task order level and mandated set asides if two or more small businesses could do it at a reasonable price. SBA changed the rule within a month of that decision coming out to overrule GAO effectively and move it into this world of CO discretion. And that's just where we still are. So even with this far rewrite, COs have discretion to set aside orders under multiple award contracts, but it is not mandatory. And that also falls in line with the changes that SBA made in its regulations in 13 CFR last December, so almost a year ago now. In those changes, they clarified, SBA clarified that contracting officers have the discretion, but not the mandate to set aside orders under multiple award contracts. And now it's also been clarified under this FAR rule and 13 CFR that the multiple award contracts being spoken of also include GSA schedules. So any multiple award contract, they can set something aside, but they don't have to set it aside. Now, under this new FAR rule, the government is trying to say that you can't protest that determination. So, for a task order, if they decide to not set it aside, that's not something under this new FAR rule that could be challenged, saying the government didn't properly evaluate under the revised or the new rule of two because their market research was bad and it should have been set aside. Because the reality is, from both a legal perspective and a practical perspective, that because contracting officers have the discretion to do it, even if you could protest that determination, that would be a very high bar because you're not arguing that the contracting officer violated the law. You're arguing that they abused their discretion. And that is a much more difficult standard to meet, an abuse of discretion standard, because it has to be beyond the pale, like completely unreasonable. And that is extremely hard to prove, if not impossible in most cases. I don't see this as being a major change either. It's just something that to note that if you can talk to your contracting officers, still be out there, still make sure you're marketing folks, and because they have discretion to use any type of set aside, including small business, right? You could get out there and you could talk to your folks and market your government officials and try to get them to push it in a direction that is best used for you. I also recommend always, and historically have, I recommend doing that for NAICS codes as well. If there's a particular NAICS code that's higher or lower than what it was on a maybe a prior procurement, you can certainly market the government, try to explain your position as to why a different NAICS code would be appropriate, and then attempt to put it on there to shift the landscape a little bit. What this does give you though is if something's been historically, let's say, hub zone, you could tell the government that you don't have to keep it hub zone and just make it small business so I can compete and you're going to get more competition and it's going to be better pricing and everything else. You could make that argument now more directly and point to something in the new FAR. On that same sort of line, and this is something that if you're an 8A company is bad, if you're not an 8A company is probably really good, And I've also actually heard a number of 8A firms think that this might actually help a lot of 8A companies, not hurt them. And I'll explain why. So, previously, if contracts were awarded under the 8A program, you'll hear this thing of once 8A, always 8A, right? Once they were accepted by SBA into the 8A program, that same requirement could not be removed from the 8A program unless SBA allowed for the removal or the release from the 8A program. FAR 19-108-11 makes follow-on 8A contracts available for set-asides under other programs without SBA approval. So under the new FAR regulation, a procuring agency doesn't necessarily have to worry about the fact that a prior contract was 8A. Now, the reason, but before they choose where to put the follow on, the reason that this might actually be good for 8A companies is if you talk to contracting officers within the federal government, a lot of them for especially new requirements that have never been let before. So let's think about emerging technologies and like AI issues and drones and every these a lot of new technologies are going to and things you haven't even thought of. New technologies are going to constantly come up or new requirements are going to constantly be developed under the federal government over the next decades. And in the past, a lot of contracting offices would really think twice about making something an 8A set aside because once they did that, they felt like they were tied and stuck and they couldn't remove it because they'd have to go to SBA to say, Mother, may I, every time they wanted to remove something from the program. If they don't have that constraint anymore, it actually allows 8A companies more flexibility and probably a better bargaining position to talk to the government and suggest that something be set aside for 8A for this particular contract. And when the government says, okay, I can see that. You've shown me that there's two, three, four, five, 10, whatever 8A firms that this could be really good for. We like you, you're an 8A company, or we like your new joint venture that's 8A, whatever it happens to be, whatever your marketing pitch is. And they might say, I'm game. For this particular procurement, let's set it aside for 8A. You've convinced me. Let's do this without having to worry about, oh my gosh, if I do this time for this set of requirements and this procurement, I'm going to be stuck forever. That really makes people think more, right? About whether or not they really want to do something as opposed to it's just this one contract. And if things go completely sideways and I terminate for convenience, I can put it out under just vanilla small business if I want. That sort of flexibility really takes the weight off the shoulders of the government officials so that they're just making a decision about the here and now, not the forever. And that is actually probably a good thing. Now, it makes it so 8A firms can't challenge a contracting officer's determination to not set aside another procurement, the follow-on procurement for 8A, but at least for new requirements or that sort of initial pitch, it should make it actually easier to make that pitch. That being said, you're put on the same level as everyone else. So, from the flip side, if you're not an 8A company, it is also a great idea to then go to the government and say, look, once 8A is not always 8A. You can remove this from the 8A program. You don't need to go talk to SBA anymore once everything goes final. Let's just go forward and set it aside for serviceable vet or woman owned or whatever other just vanilla small business. You can now make that pitch if you're not an 8A firm, and contracting officers should be able to make that determination and move forward with that procurement decision. The other thing with 8A contracts is that before they issue sole source awards, contracting officers are really supposed to look at whether or not competition is something that is feasible instead of the pure easy button. Now, what I have seen the practical reality of right now, and I know these are not completely final yet, these FAR changes, but the government has still been following the easy button method in a lot of these 8A procurements and issuing sole source awards and things of that nature. Especially, I can see it happen if The government reopens, there's procurements that have to move, and there's a risk of a real shutdown. Let's say it reopens before Thanksgiving, and then it looks like it's going to shut down again in January. In that scenario, you might see things towards the end of the year or the days leading up to a potential second shutdown where the government just starts making sole source awards and they say, well, maybe the argument is competition isn't feasible because we have uncertainty and we need to get things moving and it's critical that we make certain awards. I could see that happening. And there's also questions about the protestability of these determinations because they're supposed to be pursued, these sole source awards, if competition isn't feasible. Well, what does that really mean? And these are all things that I think, or is a good example of areas where streamlining language and removing words and removing certain definitions and taking language out of the regulations is actually going to create more litigation because once you have gaps in the regulation or in definitions, the way those are filled in our legal system is through litigation and courts and judges filling in the blanks. So that's what I think is going to actually happen in not just this area, but a whole host of areas in the FAR rewrites, is that the more that has been removed from any section of the FAR, the more gaps will exist in real world applications, the more litigation will occur, and the more that judges will have their say in the interpretations of what the rules mean. And when you're talking about GAO and the Court of Federal Claims, which is where most of these things are going to end up, they can also be distinct and not agree with one another. And even within the Court of Federal Claims, different judges are not binding on other judges at inside the Court of Federal Claims. You have to go to the Federal Circuit for that. Just be aware that some of these things and some of these open questions that might exist are things that are going to have to be answered by judges on a going forward basis. As I noted, I think there's a lot of these things that once 8A, always 8A, and it meant that SBA had to approve things, and that also there was this mandatory source requirement under FAR Part 8, right? That they were supposed to go 8A in certain instances. What is interesting, though, is that while in this old FAR Part 19 and the shift to the new FAR Part 19, right, where they remove some of this language here, that now the once 8A, always 8A isn't a permanent fixture. The agencies that use the 8A program have an MOU with SBA in order to allow them to use the 8A program because unlike service-able vet or woman-owned or hub-zone or vanilla small business, the 8A program is a program whereby the agency contracts with the Small Business Administration as the prime contractor, and then the Small Business Administration contracts with the actual contractor that is an 8A certified firm. So essentially, the 8A company is a subcontractor to SBA. Because of that unique relationship, the MOU is what allows that to happen. And the MOU terms have not changed. And my understanding is SBA isn't convinced that they should change or that they are supposed to be changed. So that would then mean that if an agency decided that the once 8A, always 8A was no longer the case because of the FAR rewrite, and they decided to release something of their own accord, the MOU still actually requires the agency to go to SBA. So there's an open question about what SBA is going to do and how they're going to treat these things. Now, presumably, with the current administration and the current individuals within SBA, that at least at the political level, that they would follow these FAR changes because the FAR changes are coming from the current administration effectively, and that they would go along with some of these things and not necessarily push back or rock the boat. But if the FAR rewrites go forward as they've been proposed and the MOUs stay in effect and they're not revised, or if a new administration comes in and if there is a revised MOU, they shift it back to the way it was, then there could be a situation where even though the regulations have changed, the once 8A, always 8A, or other requirements in those MOUs could be enforced. Again, there's sort of a shifting landscape here that is going to have to be monitored, and everyone's going to have to be paying attention to what's really going on the ground and how things are being treated, because SBA historically has done a lot of shifts in policy without necessarily changing regulations, and this could be another indication of that. Like, for instance, if you have 8A contracts and you do an asset transaction, historically for decades, you would have to get a waiver of the termination for convenience provision. Otherwise, SBA would recommend that the 8A contract get terminated if it's moved from one contractor to another, even if it's to another 8A. And then through a policy shift after STARS 3 came out, not changing the regulations, just policy changes, SBA determined that the waiver regulation no longer applied to asset transactions, and instead you had to do a substitution under a different regulation. Those sorts of policy shifts without regulatory or changes in statute are things that you do have to be paying attention to, and it can certainly cause frustration, not just for contractors, but for us too, for lawyers as well, because some of these changes are not announced. Like that one I just mentioned is not something that's announced, and these changes just occur or you hear about them anecdotally as you attempt to take certain actions. Like as we work through an asset deal, let's say for a client, and there's been this policy change that has just occurred behind the scenes at SBA, until we do the first one or someone else does and we talk to colleagues in the industry, nobody knows that that change occurred. So that is where we're going to be with some of these things with the once 8A, always 8A, is looking at how SBA is going to be treating it. Are they going to enforce the MOUs? Are they not going to enforce the MOUs? Are they going to change the MOUs to fit some of the FAR changes? Are they going to amend 13 CFR to incorporate some of these new changes in FAR Part 19? All of that is still something that is open, and we're going to have to be paying attention to that as these things really go final. So I think those are some of the big points on this, like once 8A, always 8A piece, and looking at how SBA and the agencies are going to cooperate in order to get some of these things done. But overall, the new exceptions here, it limits SBA authority if coming in, at least the FAR does. Again, the MOUs are a different story. But the FAR changes would give more discretion to contracting officers. It allows them to look at their specific needs and then make determinations on a procurement by procurement basis without having to worry about what was done previously or by a colleague of theirs or something of that nature. And no small business is favored over another. Everyone is supposed to be on the same level playing field, and you no longer have to be going to SBA to ask for any sort of mother may I or anything like that, which again could be a boon or a bane for 8A companies depending on their sort of marketing push, what their competitors are marketing, how hard they're pushing, and the overall landscape of the procuring agency they're going after. Because the goals for disadvantaged businesses, woman-owned businesses, all of those goals still exist. And so it could be a good push for anyone. If an agency has missed its goals in any particular area, you should still be marketing those agencies to put things out to meet their goals because they're still factored in and still looked at. Because, as I noted at the very beginning of this, it is still the federal government's policy under this new FAR Part 19 to maximize awards to small businesses, including the socioeconomic categories. But one thing I will note as well on socioeconomic categories, though, is there has been a rumor that the service disabled vet goal might be doubled. So it might go from 5% to 10%. If it goes from 5% to 10%, and we've seen changes like this that are non-statutory, non-regulatory in the past, right? Where the Biden administration increased the threshold for 8A firms. That could occur again, but for service-able vet, and it's something that could easily be done because it's just a goal. But if they do that, if the administration does that, it could be a sign that, look, we should shift, or you should find teammates that are serviceable vet if you're not, and kind of push into that area, even outside of the VA, because I could see a fairly strong push to ensure that those goals are met just for political reasons. So it's something that could be looked at and into just something to keep in mind as things go forward, as we look at some of this. Again, they still have to sit there and look at whether or not there's going to be something that is going to be set aside or not. SBA is still supposed to look at whether or not things are going to be set aside. If the agency has failed to achieve various goals, they're still supposed to be looking at those goals because under the Small Business Act, they're supposed to be pushing for it. But when it comes to some of these task and delivery orders, which I know more and more work is shifting into that model as you have best in class contracts or GSA schedules and things of that nature, that shifting to task and delivery orders actually means that some of these issues in the rule of two might no longer apply. And that in addition to that, some of these 8A changes as well won't be as important in that context because they really didn't apply the task order level anyway. And certainly under these new rules, they absolutely don't apply, at least outside of that little MOU quandary that has occurred in the past. See, I just saw a potential question. I was going to see if there was a question in the Q&A.
I just want to remind the audience, please do not raise your hand. We are not going to unmute audience members. Submit your questions in the Q&A. If you are having issues seeing the Q&A channel, we are now monitoring the chat. Go ahead and submit it there. We'll monitor chat and I'll moderate for Sai. But yeah, please use the Q&A channel to submit questions.
So yeah, and some of these questions, I'll just go through some of these things. So if an RFQ is on the street, it's well over 400,000, doesn't have to be set aside. Yeah, so under the new rule of two, right? If it's over the simplified acquisition threshold, it's supposed to be set aside, right? If two or more small businesses are capable of providing it at a fair and reasonable price with all the delivery. So there's those other nuances that they're going to look at. So there is no such thing as it is X dollar value, it has to be set aside. There's that wiggle room as is it fair and can it be provided by two or more small businesses? Because if it's only one, it doesn't have to be set aside. Can it be awarded a fair and reasonable price? Because if the answer is no, it doesn't have to be set aside. And what about the delivery time frame and the quality of the products or services you're looking for? Eh, That those in particular are things that are open to interpretation, right? They're more quantitative than qualitative, and so or qualitative and quantitative. So instead of that, that still gives a lot of wiggle room, I think, whenever you're looking at some of these questions and some of these issues. And the same thing where there was a question about the rule of two being retained for small businesses but eliminated for socioeconomic. That's not true. So the rule of two never mandated the use of any particular set aside type. It just mandated the use of a small business set aside. So that has really been unchanged here. Now, I noted at the very beginning that there was a mix-up in the language of the regulation years ago that actually put HubZone first, but that was a drafting error and it got corrected. And so there's been parity across programs ever since then, except the once 8A, always 8A, which we've hit multiple times. But when it comes to certain socioeconomic categories, the contracting officers under the current rule of two and the old one have the discretion to set them aside if they want to set them aside for any of the categories if they can meet that rule of two standard, but they don't have to. Moving on to another area here, when you're looking at contract level recertification, the new FAR requirements have eliminated re-representations at the order level. So contracting officers should no longer be asking for recertifications or re-representations, as it's called in the FAR, at the order level. So once you've made the determination or you've bid on a contract and you've certified as small business or hub zone or whatever it is, that should attach for the life of the IDIQ contract. Now, that doesn't mean that if you don't trigger a recertification event under 13 CFR that you're scot-free, right? Because you need to still look at 13 CFR and all the rules in 13 CFR, because that is going to actually trump. And so if you have a situation where you say, well, hey, the FAR Part 19 eliminated the order level re-representation. So if I'm bought by private equity or if there's some other re-representation issue, I change my ownership structure or something like that, and I trigger recertification under 13 CFR 125.12. If you do that, all the implications of 13 CFR 125.12 will still attach. I guess there could be litigation on that point about whether or not the FAR Part 19 changes would trump the 13 CFR regulations in certain contexts, but that has already been well tread territory in the law. And the courts and GAO have already determined multiple times that because Congress delegated authority to SBA as to matters of size and status, that things like recertification or re-representation and the implications of those things still rest with SBA. So unless the judges change their mind, which is always possible, because this is all case law driven, then you just need to understand that because there is this discrepancy now on the impact of re-representations of size and status in 13 CFR and in FAR Part 19. Also, FAR Part 19 removes all the references to SBA's authority in dealing with the set aside contracting. So clearly, there's this shift to put more power in the hands of contracting officers, and that's been done across the board in all of these FAR rewrites. But you still have that problem with these issues that Congress delegated authority to SBA, not the FAR Council. So again, this is something where in anything where they're taking authority away from SBA and moving it into the hands of the contracting officers, there could be some vulnerability there if people go to court on those issues, or if the administration changes or a new administration comes in 2028 that it has a different view, then SBA could be put in a position or told to reassert its authority without changing any text, right? Without changing FAR Part 19, if this goes final, without changing 13 CFR, it would just be that policy shift that I talked about, where they could just come in and change their mind and start enforcing something. And think of it like the speed limit, right? If you've got a speed limit outside of your neighborhood and there's never cops there, does that mean the speed limit doesn't apply? No, it just means no one's policing it, right? The speed limit has always been 25 miles an hour, whether you're going 50 or you're going 15. And if a new government, local government comes in and says, put 5 police cars on the road every day, and now everybody's getting tickets, the law didn't change, just the enforcement changed. That's the kind of thing that could occur. So it's just something to be paying attention to. And It also removed some of these things with the subcontracting programs and how SBA should be looking at the subcontracting or approving different subcontracting goals and looking at the plans, or should government agencies have to go to SBA to approve changes in subcontracting plans and things of that nature. Again, they're trying to move it into the hands of contracting officers so that there's more flexibility and less delay and lag time and bureaucracy in discussing different things so that government procuring officials at the agency level can just act without having to deal with third parties like SBA. Again, there's MOUs though that are in effect, so we'll have to see how this is going to actually be policed. I think currently, because it's this administration, SBA will probably just let it happen and they're not going to get involved, but well, again, we'll have to see. Again, there are also discrepancies here and gaps in the rewrite because after a contractor represents that it's other than small, the agency, even under the FAR 52-219-28, right? Agencies are no longer supposed to include the value of options exercise or modifications or other things towards their small business goals. Whereas going back, they're no longer supposed to actually require re-representation at the order level. So if they're not required to do that, then in theory, they would be able to take credit for everything. But you've got FAR 52-219-28 and you've got 13 CFR 125-12, which specifically say what the implications of a recertification or re-verification are at the order level. So again, these things haven't been completely consolidated or put together in a way that one change over here ripples across everything. There are different places where some of these rules are implicated. And frankly, I've never understood that. I feel like if SBA's regs govern, it should just be SBA changes the rule and it should automatically change the text of whatever the congruent FAR provision is. That's not the case though. So in here we still have this sort of gap that I touched on before, but it's also a gap between FAR 19 and FAR 52, which is also just an interesting note here that there's this outstanding issue. It also doesn't really address eligibility for options. Again, there's that gap. It's the same sort of gap I was just talking about. What are the effects of recertification? And there's language in FAR Part 19 that says, look, you can't, the contracting officers aren't expressly told you can request recertification, but it doesn't prohibit it either. And so that's also interesting note because if you go look at FAR Part 1, it says anything not expressly prohibited is allowed. So it's almost more of a policy change, is what I would call it, that they're not supposed to be seeking re-verification or recertification, but it doesn't mean they can't. And so that would be another question, I think, for the courts to look at how strong that language is. Also, when you're looking at size or status protests at the order level, they left in that sort of language too, right? So if recertification is requested, then you can protest it. But if it's not requested, then you necessarily can't protest it. And also, there's a whole body of case law at the SBA's Office of Hearings and Appeals about when OHA has taken jurisdiction over certain protests. And all of that still is going to apply because if someone protests someone's size or status, it doesn't go to GAO. It doesn't go to the Court of Federal Claims where the various FAR provisions and laws and regulations are looked at. It goes to the Office of Hearings and Appeals at SBA, OHA. And OHA is going to look at 13 CFR because that's the mandate it has under the Small Business Act is to follow those rules. Now, certainly, I think people will make arguments that FAR Part 19 is changed and therefore that should govern. But again, there's plenty of case law that says the opposite. So this is just another area where we might see people try to get creative, try to make some arguments, and try to protest things, but we'll have to see how that actually gets ironed out. When you're talking about M&A activity, same thing, right? If you're acquired, it's going to trigger recertification under 13 CFR 125.12 with all the issues that I've already talked about. So again, that it's not a get out of jail free card. It's just something that is maybe even thrown just some confusion into the mix more than anything else. So I think overall, right, what we're dealing with here is that contracting officers should have more flexibility in what they're doing, which has been a key driver of a lot of these FAR changes. Put the authority and the discretion in the hands of the contracting officers, right? There should be increased competition, even in the context of an 8A, even if you've heard that there's going to be an 8A sole source procurement, so you're not an 8A company, you can try to push for that procurement to go competed at the very least, because there's now this big push for competition, and they're not supposed to be doing sole source awards without actually making sure and looking at the viability of that competition. There's some limited application here of, well, what's FAR Part 19? What's 13 CFR? How are they going to interact with each other? There's still time to put in your feedback and respond to some of these changes. Give your thoughts. What are things that they should change? Should they try to address some of these issues? Now, I don't think they can do it unilaterally in FAR Part 19. There'd have to be some coordination with SBA, but these are certainly items that are being raised and that we've been raising as well. And in our feedback, in our comments to the rule that our firm is going to put forward, there are certain things that we would certainly like to see and like to see clarified on some of these issues. Because again, if they don't, it's going to be the courts that make the determination. And that's what I've been saying in both some blogs I put out and on a lot of different webinars and things, is that when you remove language, when you make something simpler or you think you're making it more simple, you're leaving gaps. And when you leave gaps, you're going to have courts fill them in. And once courts fill them in, if the regulators don't like what the court decided, they're going to issue a new regulation to plug that gap. And by the way, do you want to know why the FAR or FAR Part 19 or 13 CFR or any of these regulations are so voluminous? It's because of that feedback loop. And that is something that is just baked into our legal system. Courts make decisions as to what the law means. That's what the Constitution says. And when courts make those determinations, Congress or regulators might not like it. And when they don't like it, they are supposed to change the law, which then makes it so there's new text that can be interpreted by a court. A court will make a new determination. And if they don't like it, they'll change it again. And over time, that's why you get more and more regulations tacked on, because there are new facts and circumstances that occur. There are new changes in language that need to be interpreted. And all of this is why laws and regulations get built up over time. And that is frankly baked into our constitutional system of government. And it's not something that can just be stripped away and changed because any one group of individuals decides that it's time to streamline something. All this is going to do is sort of take you back to a time when maybe there was less text, and then it's going to be built up again. That's inevitable. Even if nothing changes as far as different administrations or different viewpoints on some of these things. So just be aware of that, be prepared for some of these things. Let's see this whole idea of SBA still being in control of certain areas. We'll have to see what that actually looks like in practice. There's the M&A issues still exist on recertification and the implications. Keep your eye on that if you're looking to do an acquisition or sell or something of that nature. There's that January 17th, 2026 date, which is when the new SBA rules for multiple award contracts and the implications of recertification go into play. Those are still live, and this FAR rewrite hasn't necessarily changed that. But because of the broad discretion now given to contracting officers, check with your contracting officer, market them, push them, try to steer things in the direction you think is appropriate because they do have more flexibility now and they can operate in this better environment. And then sort of lastly, as I said many, many times, this is an evolution. And so you need to be prepared that this will continue to evolve over time in both the text of regulations as it goes final, in what SBA does in 13 CFR, in FAR Part 52, which are all the contract clauses, and then also just generally policy and case law. And so, as these things are moving forward and as we see the practical reality of some of these impacts, we're going to have to keep a close eye and be flexible. So whether you're a contractor or you're a lawyer, you're a proposal writer, or you're an M&A advisor, or you're an accountant, or whatever it is, all of these things are going to be changed and determined over time. And if this is sort of a great reset, you're going to see these things evolving over decades to come. And so just be prepared. And I believe we are out of time. So if there's
We
any other
are.
questions I didn't answer, we'll follow up.
If you have 10 more minutes and the audience would like to stay with us,
Yeah.
Sai, we have a few questions in the Q&A, and I'm going to go, Robert, who has been waiting for a long time for his answer. He says, will you be discussing the non-manufacturer rule? Specifically, small business must provide the end product made in the US by another small business and what the minimum value is. Is there any impact on that ruling that we need to talk about?
Yeah, so the non-manufacturer rule hasn't really changed all that much because again, that is in really the non-manufacturer rule is a 13 CFR rule. At the end of the day, that goes to the same issue as if you have some sort of conflict between SBA and the FAR, what really governs, or FAR Part 19 or FAR 52 and 13 CFR. But the reality is that under 13 CFR, which under the current case law should be the governing rule, that the non-manufacturer rule is still in existence. You have to provide, generally, unless there's a waiver, you have to provide the end product of a small business in order to be considered a valid small business non-manufacturer. And a small business has to be someone who is in the US or would otherwise qualify under the rules. So, generally speaking, if there is a product that is not manufactured or it's not from I shouldn't even say manufactured, it's not from a US company, because in theory, you could have something where there's a US company. Like, let's take bananas, because that's a case I had years ago, which is funny enough, but there is no domestic source of bananas. In theory, though, could you have a small business that buys a farm in South America where they grow bananas and then import bananas? And so you're getting bananas from a small business banana producer. In theory, that would qualify. That still is the case. And as far as the value is concerned, the rule automatically attaches to anything above the micro purchase. And if it's above the micro purchase and the simplified acquisition threshold, it should be applying, and then above the simplified acquisition threshold. So that's also shifting. The simplified acquisition threshold might be going up to 350,000, but we'll have to see as things sort of concretize around that what exactly it's going to be. But if you've got things below 250 or if it goes to 350 and the micro purchase threshold, which again is also potentially going to go up, but if it's between those two thresholds, then technically the non-manufacturer rule doesn't apply. So that could be an argument as well in that context.
Thank you. And I just want to remind everybody, we will be sharing the recording of this session. So if some of you are asking that as a question, yes, you will get a notification that when this recording is posted. Quick follow, the next question here, one of the things you mentioned is the agencies still have to meet small business goals, but for a separate, are they going to separate that out into WSB, SDVOSB, or do they just go to general small business?
So the goals, the statutory goals in the Small Business Act are still there. That has not been removed by Congress. So the administrations, like I said before, have increased them in the past, but they cannot decrease them. Again, though, they're just goals. So there's no mandatory responsibility to meet those goals. They're just supposed to attempt make good faith efforts. So when you're looking at WSB, serviceable vet, hub zone, small business, and SDB, socially economically disadvantaged, those goals are still there. The serviceable vet might go from 5 to 10, so just keep an eye on that. We'll see what happens there. But the rest of them are going to remain the same. And the one that was lowered was the SDB goal, but it was lowered down to the statutory minimum, whereas the Biden administration increased it well above the statutory minimum.
Is there an impact of any of this specifically on Alaska Native companies or corporations?
Not when it comes to the direct FAR changes. When you look at some of the changes in other laws, there's been some increases to the sole source threshold. So it's gone up to 35 million for civilian and 150 million for DoD. Now there's some kind of controversy about whether or not that's directly applicable yet. The DFARS has come out with a deviation to arguably not follow the 150 and leave it at 100 for sole source awards under DoD procurements. At the same time, my discussions with SBA and other folks is that they believe that the 150 does apply and that there's an argument that if contracting officers want to use it, irrespective of the DFARS deviation, that they could. So those, I think, are the main changes when you're talking about tribes, ANCs, and NHOs.
Okay. Another question. Do you have any insight on how socioeconomic pools on best in class will be impacted? Are they going to be collapsed into just small business, the different socioeconomic pools?
So again, the goals are still there. And the way the FAR rewrite has been done, and if you look at the policy at the very beginning, it's still in its text form, at least, the black and white says that it's the policy of the federal government to support small businesses and socioeconomic programs. So there's no change in the FAR provision that would lead me to believe that there's going to be any change in the from the policy perspective. Although from a practical reality, we'll see what happens. I think there could be a pullback from certain things like 8A. I mean, we've definitely seen fewer 8A contracts, so there could be some pullback there. But that could be a boon for serviceable vet and veteran-owned companies because, like I said, there's a thought that it would increase that. So I don't think in current contracts, I don't think they're going to mod them to eliminate pools or collapse pools. And then on new contracts going forward, because of the way the goalings are structured, you're probably going to see them being pretty similar. It's just a question of where task orders come out and then standalone procurements, how many are going to be pushed for, one political reason or another, which is not really that dissimilar than what's happened in the past. It might just be there's going to be different winners and losers.
Yeah, and one of the questions is about self-certification for, WSB and things like that. I'm pretty sure those were already eliminated. Self-certifications were not accepted anyways, correct?
Yeah, now just a point is that across the board, the SBA changes from last year, the generally self-certifications are removed entirely. So every program now, you have to be certified by SBA, and that was
Yes.
a sort of preventative fraud purpose.
Yeah, and it's not third party. There's somebody who posted the question. It's not third party certifications. It's certification through SBA, which they have streamlined that certification process. So please be mindful. You're not going to go to a third party to get your WSB certification like it used to be. You're going to SBA. There's a question here, and I'll try to keep it generic. One of the questions says GSA has adopted all of the RFO deviations and announced a mass mod for all mass FSS contracts in November. Won't this rewrite apply to the mass FSS orders after the November mod?
Yeah, so specifically to the multiple award schedule, then yes. So if they mod or frankly, if any contracting officer mods your particular contract, whether it be single award, multiple award, or anything like that, if the contract itself is modified to include some of the new changes, then it would become, it's not really a regulation at that point, it's a contract term that you're bound to by contract law. And so, yes, those things would apply, but that's generally true. So, for any change a contracting officer ever makes, unless it's illegal, but I don't see that being illegal.
All right, we'll take one final question here, and that is, what is the expected date of finalization of the FAR overhaul and the dollar thresholds? Do we know when that's going to happen?
That's a good question. They're a little behind, is my understanding, and they have to look through some of the comments, or you'd think they would want to look through some of the comments. And with the shutdown and potential second shutdown, if that were to occur, it could get pushed out until sometime next year. I would I would think they want to, I thought at least they wanted to have things wrapped up this calendar year, or at least get things put together, but then things got delayed a little bit. So I would say probably the spring or the summer is whenever we'll see the real finalization, but not guaranteed.
We'll wait and see. Well, thank you all for participating. We had over 450 people register for this event, and we continue to bring these educational events, and we thank PilieroMazza, Sai, for always being so informative. Again, thank you all for joining. We will send out this recording. We'll notify you where it's posted, so you can go back and review all the great information that was shared. So, Sai, again, thank you. And for those of you who need government contracting help, reach out to PilieroMazza for business development proposals. Reach out to us. Thank you, guys.
Thanks all.
Take care. Bye-bye.